Hi, Black Hollywood Live fans. Today on Justice, we're covering Chris Brown, major Supreme Court decisions, and more.
You are tuned into Black Hollywood Lives. Justice is served.
You know you got me fucked up. I don't wanna touch nobody else.
This song is just too
Physically, I'm so
perfect.
yeah.
That is Chris Brown's song, Beat It Up. That's how we're going to welcome you to this episode of Justice is Served. Thank you for joining me. My name is Chelsea Galicia, an attorney with my two co-hosts who are also attorneys, Shaka Smith and Yebi Abayami. Right? Yes?
Yummy Abayami. We're there.
Dang it.
We're getting there.
Fourth time is going to be the charm. Okay, and hopefully I'll be more charming than Chris Brown has been in his latest post. This song is so apropos, as Yummy was saying, because it's called Beat It Up, and he's in legal trouble for, wouldn't you know it, beating someone up. He beat up his manager. What were the details of that?
Yeah, so Chris Brown, as we know, he's no stranger to
Assault.
to assault.
Made me say it. Okay.
And so he had a conflict with his manager and beat him up, of course, or allegedly assaulted his manager, beat his face to a pulp. Apparently, the manager had a lot of just hospital bills associated with his jaw and things like that. And so the manager is now suing him.
So
for
Mike
this.
G is suing for this assault.
Yeah, and I mean, the injuries took him to the ER. And I think worse than the assault is Chris Brown he bragged about the beating and told people that he even had told people on his staff he would beat them like he beat Mike G. And I think the bragging about the beating upset him further.
Got it. And then we got evidence that Chris Brown did not watch last week's episode because he failed to follow Yummy's very sound legal advice, which was to be careful what you say on social media because it can come back to bite you in the legal behind.
Right, yeah. Exactly. In this case, he went on social media, posted a video in his defense saying, that.
Why don't we watch it so we can hear firsthand what his defense was?
Okay, you knew it was coming. You knew it was coming. I'm under this goddamn light to make it seem more serious.
Oh my God, he sounds so evil.
Okay. Is getting mad and filing lawsuits because I fired them because they're stealing money. You're stealing money, pal. So, you're mad because you're no longer existent. It's all right. We're going to keep pushing. God bless you. Wish you the best of luck. Mr. Petty Pants himself, I'll declare it. I'm not finna entertain this petty cause don't nobody come out clean in the throwing contest. And I can throw a big piece of shit. I'm talking about massive chunk. I'm talking about it's like elephant mixed with donkey Might even be a little bit of rabbit pebbles. But I would throw the biggest piece of So we're not gonna play these games. We're gonna let these people do what they do, and I'm gonna keep getting this money. Thank y'all for supporting me on this tour, killing it. We're gonna keep doing our thing, man. Everybody else, all that other
Well, there you have it.
So I'm glad he was able to get that off his chest. Unfortunately for him, after releasing that video, Mike G has now added a claim of defamation to his claim.
Yeah.
So
that's what happens.
be careful what you say on social media, people.
Yes.
It can just make things worse for you. Hopefully next week we don't hear something like this again. Follow my advice.
We'll see.
It's free.
Although if there's a song that conveniently related, I'm all for it.
Yeah, but I think it just, again, don't post stuff on social media. It's just that prima facie evidence of defamation is not going to bode well
Yeah,
for
that
Chris.
the ego loves to defend itself, and he may have used a lie to defend himself, which on social media, I mean, I guess you can lie all you want on social media, but that is then defamation because that went out to the world and you call somebody a liar, a thief. So you can't do that unless it's true.
he has proof that he actually did this.
But I doubt that he is paying close enough attention to his finances that he knows if money is gone
Well,
and
if
if
someone
it was
in his
stolen.
organization informed him that,
And that was the grounds for the firing in the first place. Maybe he actually does have evidence that he did this.
But Mike G wasn't fired before.
Mike G claims he wasn't fired prior, but he will still have his claims as to the assault.
All right.
And I think recently we just heard again that his publicist just left due to, I guess, the bad behavior between Chris Brown and herself. And it seems like a lot of people are saying in his life that these are drug-fueled drug-fueled behavior that's going on.
So she felt threatened, like her safety was threatened, and it kind of raises an interesting evidentiary question about whether the PR lady's testimony can be used against Chris in the Mike G case. My recollection of evidence is no, it can't, unless Chris Brown raises his own character or personality evidence first. But Mike G's attorneys couldn't bring on the PR lady to say, look at this similar behavior, because that doesn't prove, at least that's true in criminal.
Yeah.
And I don't recall if the evidence standard is the same in civil for this kind of claim. Anybody have a better recollection than I do?
Yeah, he wouldn't be able to use her in the Mike G case, but I think it's speaking to a downward spiral of behavior with Chris Brown right now. So I
So
don't
the
know
pattern makes it more obvious or likely for us to believe that it did happen, but in court that likely couldn't be used.
He might be guilty in the court of public opinion, as we would say.
Yes.
if he's picking a jury trial.
All right, so let's move on to some major Supreme Court decisions. There were several of them. Two of the biggest ones, I think, dealt with affirmative action and abortion. So the affirmative action one is a case that we covered here before on the show, and it's the case of Abigail Fisher, and she was the white girl from Texas who sued the University of Texas because she didn't get into the school. University of Texas allows all the top 10% students to be automatically eligible or admitted into the university. She didn't make the cut. She wasn't in the top 10. For the rest of the seats, and actually 75% of the incoming freshmen are these top 10% students in the state of Texas. So the other 25% are allowed in by looking at the applicant holistically, everything that they might bring, all their experiences, sports or community involvement, and all those things that I remember were looked at when I went to school. And among those factors is race. And Abigail Fisher thought that that was a violation of her equal protection rights. So she sued all the way up to the Supreme Court, who this week told her, sorry, girl, affirmative action stands. What was the logic behind that?
Well, I think the logic behind it was that there is some value to diversity in education. And I think Ms. Fisher missed the point in that. So when they're looking at different factors for students, not only are they looking at race, but they're looking at school and state and several different factors of your background that would determine what would be best to balance that particular class. You have certain private schools that are just, in terms of the talent of students, are very deep, but only 3 or 4 kids from that private school will get into a top university, whereas kids that are at the top of their class at other schools that may not be as good will all still get in, but they're factoring in the diversity and the different experiences those students bring to the classroom.
Yeah, and so the justice who wrote for the majority, was this Kennedy, said that there's like intangible factors that we can't really articulate, and we're going to defer to the university to make up a diverse student body that they believe is going to be best served at their school. Did you think that that was a good reason to keep affirmative action?
He emphasized in his decision that the school was very concrete and precise about why they wanted to, why diversity mattered to them, the desire to have their students be prepared for a diverse workforce, to encourage leadership, things like that. And so, as you said, universities are allowed to establish what their reasoning is, provided that it's a reasoned explanation for why they're pursuing this goal. He did clarify in the decision that the process that you use, if you're taking into account this racial consideration, the process that you use has to be narrowly tailored. So that still holds. You can't just kind of impose a quota. And so he emphasized that even in this instance, race was just one of many factors that were involved, and even cited that kind of the small impact that it had on the number of minorities was evidence of this narrow tailoring.
Yeah.
And
so I was going to go back to the reason that we had initially covered this case, aside from it being an affirmative action case, was because of Antonin Scalia's comments during oral arguments. So Justice Scalia said, I can't believe, out loud, he questioned during oral arguments, well, maybe it's not such a great thing for African Americans to go to these schools that may they may not do well there. They should go to slower schools. How else did he less advanced, he said, and we were all shocked that somebody would say that, but not so shocked that it came from him. And since then, he has died, and that may or may not have changed the outcome of the case. What do you think the impact is of Scalia no longer being on the court for the case?
Well, I think it's huge. Certainly, this was with a swing vote with Kennedy here, and it was a tight vote, and Kennedy has, at different times gone back and forth on affirmative action. So it's definitely a big impact not having him on the court and probably having his opinion to Justice Kennedy, who was a swing vote here.
Yeah, this was a 4-3 decision. So if Scalia was still there, it would have been a 4-4.
Yeah, and there was one of the justices was recused because she had worked on it before, so that's why it would have been 4-4.
But I did like something Kennedy said in the opinion, which was that the university has an ongoing obligation to engage in constant deliberation and continued reflection regarding its admission policies. So that the factor of race wasn't something that was kind of rubber stamped, but it was something that he felt they did have a nexus to need now to increase their diversity and, I guess, quality of the class. But they need to continue to look at it in the coming years and see if it still held value.
Yeah. So for her part, Abigail Fisher said she was disappointed, obviously, and that she was hoping for a day where we would move beyond affirmative action. And to that I say, yeah, Abigail, I wish that one day we can move past it because it's no longer an issue and everyone's on an even playing field.
Yeah.
Until then, I think it was a good decision.
Yeah.
All right, so moving on to abortion. This was a Texas case that arose because Texas is among a handful of conservative states that has passed laws restricting abortion. There were two specific laws that were tried here. One, Texas wanted all doctors who were performing abortions to have admitting privileges at nearby hospitals, which means that they're allowed to practice in those hospitals. The problem with that, among other things, is that this nearby requirement was like 30 miles away. And I'm not sure if you've noticed, but Texas is a pretty big state, and there's not always a hospital within 30 miles of the clinic. And so that would have forced about half of them to shut down. And then the other law that was up for debate was this idea that a clinic should sort of resemble a surgical center or like a mini hospital with wide hallways and other requirements that would make it what proponents of the law say would make abortion safer for women or would protect women's health. It didn't fly. The Supreme Court said no go. Yemi, what did you think of the proponents of the law saying, well, this is about protecting women? Did the court buy that? Do you buy that?
I can't say that I buy it. It's funny, even after the decision came out, a lot of these anti-abortion legislators in Texas, they started speaking as though they were going to war. I mean, they said things such as, the fight isn't over. We're entering into a new phase of an old battle. There's going to be an onslaught of legislation coming. So even though this was a victory for pro-choice advocates, I think they also need to be prepared to be seeing some new legislation coming down the road. There is a group, Texas Right to Life Association, that helped author the bill in the first place, that said that they are going to continue their efforts to curb access to abortion. So it's clear that there are some, additional issues going on aside from just, we want to protect the health of the mother.
I don't even think it has anything to do with protecting women's health at all. It is completely about access. Mm-hmm. I don't know if the court agrees with me that strongly, but their opinion indicates that they didn't buy it either. They found that these restrictions placed an undue burden, and a 1992 Casey versus Planned Parenthood case said that there can be restrictions and things, but they can't place an undue burden on a woman's ability to access abortion, and the court said that this did place an undue burden on women.
And they did find there was no significant health-related problem that the new law needed to cure, so they found there was no problem that this would actually help. But I did kind of like Alito's dissent here, where he thought they should be taking the different provisions separately.
Like analyzing them separately?
Analyzing them separately to see if any part failed and if any part could remain.
I think both of them fail. I have seen the arguments for why both of them are unreasonable, and I didn't think that either one of them had anything to do with women's health.
I thought that the majority opinion was really clear in talking about the requirement for having admitting privileges not necessarily being reflective of a doctor's competence or their ability to perform an abortion.
Safely.
Oftentimes, these admitting privileges might be conditioned on being a member of the faculty or accepting a faculty position, let's say at a university hospital, or let's say even having residency requirements, things that don't necessarily indicate, and also they also require, they give admitting privileges based on the number of admissions that you might have to a hospital. So if you live 30 miles away, you might not regularly admit people to the hospital. Yeah. So there was no correlation between the requirement to having admitting privileges and the doctor's ability to perform a safe abortion. And they emphasize the same thing with respect to the surgical centers, talking about how the requirements that you might have in a surgical center, it might not be appropriate in the case of abortions. A lot of the requirements, as you mentioned, involve the size of the hallways.
So that like 2 gurneys could pass, but
exactly.
That's not happening.
Having scrubbing rooms, having certain high walls, sterilization centers, which, yes, are important, but are in place more so because of procedures where you're penetrating the skin, whereas in an abortion procedure, you might be giving medication or entering through the birth canal. You're not really penetrating the skin in that way. So he's just saying that there was no correlation between these needs, or that the correlation wasn't such that it was so appropriate and adding additional safety nets for women seeking abortions.
But I think Alito was highlighting that they did not do the analysis separately for each of those.
Oh, come on.
Well, I think for the sake of procedure and analysis and the way we do have the courts break down these different provisions, I think procedurally, I actually agree with Alito. And I don't agree with the outcome he wanted, but I definitely procedurally agree with the way they should have analyzed the provisions.
All right, then. Now, this was a Texas case, but it has widespread ramifications. There are other cases, states, Alabama, Mississippi, and Wisconsin, that had this admitting privilege law, and then Michigan, Missouri, Pennsylvania, Tennessee, and Virginia have the surgical center law. So all those, will they just be wiped out automatically? You think that those states have any real good faith reason to believe that their laws are constitutional, or they just drop them?
I think it'll cause them to think twice about the types of restrictions that they're putting on these abortion cases. I think there's also, though, the fact that this is a huge ruling, but it's not necessarily going to be immediate. As you mentioned, a lot of these abortion clinics had to shut down. So maybe half of the ones in Texas, for example, shut down. And so now they have to go through the process of reapplying for licenses, restaffing the facilities, getting, revitalizing the equipment.
And that's the problem with these restrictions, is that they can just kind of reword them and then have them come back anew, so there'll always be an assault on abortion. But I think we had a 5-3 decision here, and I think it looks like we may have another president who is going to be Democratic, so hopefully abortion is going to be protected from further onslaught.
Yeah. All right. But in the last couple of years, there have been like hundreds of these laws around the country. It's been interesting. We'll leave it with that word. And then we will shift to a word from our fabulous sponsor, who allows us to bring you this show for free every week. Take it away, Yemi.
Small business owners, it's time to be honest about how you feel when dealing with your day-to-day administrative work. Admit it, you can't stand it, it's a total grind. The truth is, over 5 million small business owners felt exactly the same way until they discovered FreshBooks. For those of you who haven't heard about FreshBooks, listen up. These folks are on a serious mission to help small business owners save time and avoid a lot of the stress that comes with running their business. FreshBooks is the dead simple cloud accounting software that's transforming how small business owners handle their paperwork. Using FreshBooks to create and send an invoice literally takes about 30 seconds. There's no formulas or formatting, just perfectly crafted invoices every time. Your clients can pay you online, which means you end up getting paid a lot faster. There's a super handy deposit feature so you can invoice for a payment up front when you're kicking off a project. FreshBooks even shows whether or not a client has looked at the invoice you've mailed. This is only a fraction of what FreshBooks can do for you. FreshBooks has created a super intuitive tool that makes creating and sending invoices extremely simple. It's fast, all online with instant notifications. Plus, send automatic late payment reminders, and you can create custom branding to reflect your business. You owe it to yourself to feel the full effect of FreshBooks on you and your small business. Plus, if you have any questions, their customer service is absolutely fantastic. No robots, real people. They care so much that if for some reason after 4 rings, someone from customer service can't pick up your call will be routed to all employees at FreshBooks, so you're guaranteed to get help. For a 30-day free trial, just go to freshbooks.com/geek, that's GEEK, and enter Geek Nerd Tech in the How Did You Hear About Us section.
All right, great. Thank you so much for that. And moving on to an update about a couple of police abuse cases that we brought you, Freddie Gray and then the McKinney pool party. First with Freddie Gray, the third officer to be tried and get off in his death. So you'll remember Freddie Gray was the gentleman who was arrested for really no reason, like literally no reason, cuffed, placed in the back of a van, and emerged with spinal injuries and died 7 days later. 6 officers were arrested. This is the third one to be tried. This was the driver who had been charged with the most serious crimes, including depraved heart murder, a second-degree murder charge that carries a maximum sentence of 30 years. And he was indicted for second-degree assault, misconduct in office, reckless endangerment, and 3 counts of manslaughter. No criminal conviction at all. This was a bench trial, so that means that the officer, Goodson, just wanted the judge to decide it alone. And Judge Barry Williams, who was presiding, said that the state failed to prove Goodson had malicious intentions. What is your reaction?
I was a little surprised by it.
Surprised.
Yeah.
Just a teeny weeny, oh my God.
Well, some of the other officers had been acquitted before, and then we had the hung trial and won. So I was seeing a trend, but I was hoping it would go the other way. So he didn't buckle the guy's seatbelt, and we know they've given rough rides in the past, and at one point there was concern for whether or not he was injured. So to me, I thought he will definitely be convicted of something.
This
here.
one would be the guy.
This would be the guy. So yeah, I was shocked in that sense.
Yeah, there were so many charges that he was charged with, each with different varying levels of culpability and varying levels of negligence. He had involuntary manslaughter, criminally negligent
which is why this doesn't make sense to me.
Vehicular manslaughter.
How to just say that they failed to prove that he had malicious intentions is to be like, wait a minute, do you not understand that half of these do not require an intention to kill somebody? Yeah. They just require that you know something's dangerous and that you do it anyway.
Yeah, I really thought that they failed to emphasize that it's not only, I was unaware, or I didn't know that my driving, or that without buckling him into his seatbelt, or without taking him to the hospital.
You need malicious intent for that?
That he was going to be injured. But there's also this question of, well, should you have known? And it suggests that this no malicious intent suggests that even if he should have known, he didn't mean it.
This ignores
he's not
the
liable.
history of the city, who had already had to pay out millions to other people who had been similarly injured.
And that's where I thought that the verdict was really lacking, was the fact that, for one, I think a common sense person would know that if you don't buckle someone in your seatbelt and you're driving at certain speeds and making wide turns and failing to stop at stop signs, that there's a possibility that this might cause harm. Yeah. But then you also have the added fact that there had been prior instances where people had been suffering spinal cord injuries specifically, and other sorts of injuries while being transported after their arrest. And that's what led the department to even impose this this provision where you need to
strap somebody in,
seatbelt the arrestees in the truck. So there was definitely a correlation between these spinal cord injuries and the failure to seatbelt people. And here you have a verdict which suggests that, this officer didn't know necessarily.
He didn't mean to hurt him.
Yeah.
But the other two, when the judge found or in the one where he found not guilty, and then the other one where it was a hung jury, I was like, okay, maybe, sort of, kind of, but the driver for sure. And the community is upset, has not acted. There has not been, that I have seen, any violent protests, and I commend the community members for restraining themselves, because I can see that this is a really shocking and upsetting decision. Because, as somebody pointed out, an advocate for Freddie Gay, his cause of death was ruled a homicide.
Yeah, and no one has been held culpable for that homicide.
So it just doesn't make any sense, and this case, justice was not served.
It doesn't feel like it.
No, not
at all. And then on to the McKinney pool party case. Do you remember this guy in Texas? Remember the pool party? What was it, like last summer?
Yeah.
Where there were a bunch of kids at a community pool, and apparently
Eric Casebolt.
Yes, this was the officer, arrived at the scene because there was some complaints of fighting, when it actually turned out it may have been adults fighting, not even the kids. But just to really refresh your recollection on this, we're going to show the video. Here comes the officer running. I can't. That somersault gets me every time. So this was the most controversial part, obviously, where he slams this girl. I think she's 15 years old.
Dejaria Becton, 15, yeah.
It doesn't seem that she's really dangerous. She clearly doesn't have any weapons on her. She's like hardly clothed. She's obviously in a bathing suit. It doesn't appear that this is necessary to keep the officer safe or the people around her safe. But now his knee is on her, and after just having watched Orange is the New Black last night, this is really disturbing. I won't give it away, but I mean, this is really... Oh man, all right, so thank you for that video. So this went to a grand jury to see about indicting that officer in the video, Eric Casebolt, who had already resigned. Probably was the laughingstock of town, at least in my book, because of that somersault. I don't even know. I mean, did he trip? Is that a good difference?
That looked like a really purposeful, is it a barrel roll?
Oh my God, I just can't even.
He was ready, he was
contain
stoked.
myself. That was, so this guy did not get indicted. Thanks again for playing. No indictment.
Yeah.
How do you think we got to no indictment here?
Well, the Texas Rangers did an internal investigation.
Not the baseball team. They've got an actual
the
department in law enforcement. Yeah.
So they do the investigation, and that investigation is what went to the grand jury, and we have not seen the results of that investigation. So I think that may have played heavily with the grand jury's decision, but to me it's just even that role alone kind of shows you that he was kind of hyped up.
He was amped up.
Yeah.
He was ready
Out
to
of
go.
control.
Yeah.
In his own defense, they were saying, officers were saying that he had responded to 2 calls earlier in the morning, 2 suicide-related calls. One person had already shot himself. He had also escorted another, in a separate case, escorted someone who was about to jump and commit suicide.
Then he should have taken the rest of the day off, or taken the week off.
So he was highly stressed, highly agitated.
I've been stressed out a lot. I'm a former gymnast, and I've never taken my stress out by somersaulting, although maybe I should try it. I just don't. I don't get it. And I think the interaction he had with that teenage girl was totally unprofessional, uncalled for.
And what we didn't see was how he pulled some guns on some young guys that had tried to help her, and he pulled a gun out, and so they left,
Yeah. I mean, I guess thankfully he resigned already, and the police department says I don't know what we're going to do next. Hopefully, at least an anti-somersaulting policy or something, but I don't know. Is there any silver lining here?
Well, they do have a civil case, and so maybe they'll get some sort of justice in that way. But
I'm curious to know what he's going to do next. Is he just going to join another police force? Is he going to get training? What's going to happen to him?
I don't know, but certainly in the civil case, it'll be interesting to see if anything comes of that. And that looks like all that we have for today. Thank you so much for joining us on this episode of Justice is Served. You can join us again next week, right here, same place, same time. You can like, comment, tweet, reach me at Chelsea Galicia.
You can reach me at Shaka Strong on Twitter and Instagram.
And you can reach me at Yams on Twitter and Instagram.
All right, thank you to my panel for an excellent discussion, and we'll see you next time.
From executives Keven Undergaro, Dario Kristen, Tiana Hobson, and the entire BHL staff, we would like to thank you for supporting Black Hollywood Live, the first online broadcast network dedicated to African American entertainment. For questions and comments, contact us. info@blackhollywoodlive.com. Like us on Facebook, tweet us, or Instagram us at BHL Online. And I am the official voice of Black Hollywood Live, Scipio. Instagram me at KingXOBay. Thanks for tuning in.
Hollywood Redefined.
The views expressed here are those of the hosts only and do not necessarily reflect the views of BHL or its owners or principals.